How's it going, everybody? It is your 10th favorite lawyer here, Tommy Badeaux, and we are back with another installment of what we're going to start calling BCB TV. Yep, that's right. We are going to start covering more hot button topics, prominent legal cases and issues, and just generally interesting stuff. I've had people come up to me personally. I've had people privately message me. I've had people text me actual cases and topics and news stories that they think would be interesting and I should talk about. So for BCB TV, that's what we're going to do. This does involve my profession. It involves law, so I'd appreciate it. I'm going to post them on my business pages more. If you could go like, follow, and share, Instagram, Facebook, TikTok. I'm going to try to post clickable links somewhere here, maybe here. I don't know if that's possible. I'll link them below no matter what, but maybe I'll just put the handles here at least. It's pretty much at Better Call Badeaux on most of them. So please go like, follow, share if you like this content, you want to see more. But why are we here today? Well, we're here because it's the gift that keeps on giving, people. Stage wreck case. We're here because it's back in the news. And why is it in the news? It's in the news because of Mottas. More problems, more motions. What kind of motions? Her lawyer, Sean Toomey, filed 2 new motions on April 3rd. What does he want? He wants a motion for a new trial, and he wants an appeal with the Fifth Circuit. Why does he want that? And first off, what is a motion for a new trial? Well, a motion for a new trial is exactly what it sounds like. So in federal criminal law, you are basically saying you have 14 days after a verdict or a finding of being guilty to say, hey, I want a new trial. And you have to basically say there was newly discovered evidence that would likely help or hurt, help your case or hurt the other person's case, or there were significant trial errors. So in this case, Toomey's saying there were significant trial errors. What is he saying happened? Well, he's saying that for the first thing, there was a agreement that the prosecutors were not supposed to talk about the Cornelius Garrison murder. That there was some kind of, I guess maybe handshake deal or wink, wink, nod, nod. Hey, we're not going to bring up the murder because nobody in this case is charged with that murder. But throughout trial, it got referenced, it came up, and that was something that severely hurt his client. He's also saying that he, meaning Toomey wanted to play some audio taped recordings of convicted slammer Ryan Harris at some point. I don't know if it was like a phone call or a deposition or something, but he wanted to play some kind of audio in which Harris was saying, hey, these wrecks that we did with Mottas, they were not fake, they weren't staged, they were real wrecks. And when he brought that up, the prosecutor said, hey, if you play that stuff from Harris and try to maybe portray him in a better light, we got some audio too that references how bad he is because he was involved in the killing of Garrison. So do what you will, Playboy, but I would suggest you maybe not play those tapes. So what Toomey is saying is, his words, not mine, while no trial is perfect, procedural issues at the March 2026 trial undermine the fairness of the proceedings and resulted in, where have you heard these words before, a miscarriage of justice. He goes on further. He says that prosecutors threatened during the trial to bring up the murder of Garrison, and that doing so crippled Miss Mottas' ability to defend herself. He says no defendant in this proceeding was charged with the murder of Garrison directly. That was all Alfordish, so that shouldn't have happened. Further, he goes on to state that the jury received an improper instruction on the witness tampering count, and that Jason Giles' attorney, who is Van Davis, her closing arguments were prejudicial against Mottas, and that they were allotted more time on their closing arguments, and they focused extensively on Mottas. So switching articles a little bit, he's basically saying kind of the same thing. Hey, attorneys for defendants and the government agreed not to introduce evidence of Garrison's slaying, but they did. They reversed course and allowed Mottas to not be able to put on a defense for herself. The motion states, if Miss Mottas took the stand, the government would introduce evidence of Garrison's murder and Mottas' alleged involvement or acquiescence to it. It directly burdened her constitutional right to testify or not testify. It also says that he wanted to, once again, that he wanted to introduce that evidence of the tape, but it would open the door for the murder evidence to come in, which is what they didn't want to happen. And then we got the good old-fashioned mudslinging here. So basically he said, hey, Linda Van Davis and Rick Simmons, those are the lawyers for Giles and the King firm separately. They went over there a lot of times in closing arguments. Those arguments were used to throw my client Vanessa Mata under the bus, back the bus up, and roll over her again on it. So there's just everything. He's essentially saying, hey, everything in this trial hurt my client. She's still innocent. She didn't do it. So we need a new trial. And if we can't get a new trial, I'm appealing this whole ruling because it wasn't right. It wasn't just against her. And, you know, the Court of Appeals, Fifth Circuit should look at this. So what does it do? Well, potentially it postpones that sentencing date in July. She's still being held in a federal holding facility until July, awaiting her sentencing. Usually an appeal might be filed after that sentencing to say, hey, the sentence that my client got was a little too harsh. But they're kind of putting the cart before the horse here. They're saying, hey, we need a whole new trial. And in the event we don't get a new trial, we're appealing this ruling anyway. So a new trial can open up a couple of avenues, just like an appeal can. So an appeal, you either, the Court of Appeals affirms the ruling of the lower court, you know, of the trial court. It reverses it completely, or it kind of remains it and sends it back and says, hey, you know, we think you missed some stuff. Why don't you look at this and go over it basically again. So that's where we're at. The new trial is going to be a whole new trial. And with that, you could get a stiffer charge or verdict or sentence. So that's also in play too. It could lessen it, it could wipe it out, or it could actually be more severe. But since there's no sentencing here, we don't know what the effects of that are. So there you go. There you have it. We'll await. Judge Vitter is still the one to rule on these motions, at least the motion for a new trial. There's no court date set as we sit here today, and we are still set for sentencing in July. So barring a new ruling on this, there you go. That's what you have for it on the stage trials. No news yet if Giles is going to do something. Clock is ticking on him, but there you go. So there's your staged wreck news. But remember, if you are in a real wreck and need a real check, you know what to do. You better call Badeaux and we will get you taken care of. I hope you never need me, but I'm here if you do. Stay tuned for more videos and more BCB TV. And as always, love you. Thanks for watching. Leave me a comment. Tell me what you think in the comments below. Appreciate you.